We have to ensure that everybody can serve on a jury, that there should be no economic barriers to serving on a jury. And that digital divide, whether it's the fact that in some parts of Montana or West Virginia or Kentucky, you can't get broadband, we've got to make sure that everybody, that we can expand the representatives of the jury service. Yeah. Because you want people that serve on juries to say, it was fair because I was there.
I'm Jack Newton, CEO and co-founder of Clio, the world's leading cloud-based legal software provider. In each episode of Daily Matters, we'll explore what this new normal means for law firms, how legal professionals can find success while working remotely, and how lawyers can best serve their clients during this unprecedented situation.
Today's guest is Mary McQueen, who's joining us as part of our week on access to justice. Mary is the president of the National Center for State Courts, also known as the NCSC. Mary, thanks so much for joining us today.
Thank you.
So, Mary, first of all, I'd love to ask you about what is at the front of your mind right now.
Before the last week, I said the impact of coronavirus on the courts. But obviously, given some of the civil unrest and the renewed focus on social justice, I would have to say that both of those and how they're converging is what keeps me up at night.
Absolutely. I think the events of the last week have been weighing heavily on all of us. And I want to talk more about that over the course of our conversation. But I'd love it if you could first explain to us what the NCSC does. You've got, number one, an incredible resource that I think is important that all of our listeners know about, whether you're a practicing lawyer or work at a bar association or maybe even a judge. It's an incredible resource, an incredible center for some amazing work. Tell us about what you do.
Well, almost 50 years ago next year, the 50th anniversary, then Chief Justice Warren Burger met with the state court chief justices. There's a conference like the National Governors Association or the National Association of Attorneys General. It's called the Conference of Chief Justices, CCJ for short. I just don't want to use acronyms without prefacing with that what I mean. And they met together to talk about creating an institution or a location where state Supreme Courts and state courts could share lessons learned, information. They could identify research that would inform the decisions that they make. And I think it all happened at kind of a time when the promise of separation of powers and having three branches of government that were equally important was really coming to age. And what I mean by that is up until I would say the 60s and the 70s, state courts were still viewed as an administrative agency under the executive, for instance, in the state courts. And what we've seen over the last 50 years is this development of judicial leadership. You know, whether it's in working with the other branches of government, in developing projects and improving access to justice. And so the National Center was created. I am the fourth president that has served at the National Center. I'm appointed by a board of directors that is always chaired by the president of the Conference of Chief Justices, who happens to be Nathan Heck from Texas right now. And then there's a companion organization called the Conference of State Court Administrators, or COSCA. And that's those chief executive officers, state court administrators. And that's the productive partnership of leaders that at the state court level. I served as the state court administrator in Washington State. I was there for 25 years before coming to the National Center in 2004. So we have a research division where we have some incredible social scientists, political scientists, PhDs. They tease me all the time that they have 3 letters after their name, and I only have 2. And they've done a lot of research about why do some courts dispose of cases more timely, or what is it about a particular case type that makes it more difficult to deal with. We do public opinion polls. You know, what do people think about their treatment in court? We've developed a series of trial court performance standards. We do education. We have a court services division in Denver that actually is kind of what I call the SWAT team. So let's say, for instance, somebody was having challenges with their with getting the requisite number of juries in. You know, we might go out and help them look at that. We have technology. We look at technology. We issue white papers. We issue a series of major research papers. So we're kind of like the FJC and the AO at the U.S. level all in one.
And from your vantage point, Mary, you've got an unbelievable perspective on what's going on across the nation with the courts in response to the coronavirus crisis. Can you describe at a high level what you're seeing, especially in maybe some of the most forward-looking jurisdictions in terms of how they're adapting to this new reality?
So Jack has referred to our website, and if you haven't seen it, I would really encourage, even while we're together, if you have dual screens, if you have dual monitors, to look at our website, ncse.org, because when it was first determined that there was going to be this impact of a reduction in government services, and I say that because courts never closed. We're not like Starbucks, or we're not like some of we're schools, for instance. We still have a constitutional responsibility to provide access to justice. So we did have to begin to look at what were the challenges going to be with social distancing or teleworking, or how we were going to deal with domestic violence civil protection orders. So the first thing we did on the website is to have all the chief justices in the country to submit to us court orders, their version of executive orders that were going to guide the trial courts in the states in moving forward in this new environment. So one thing that you can find on our website is you can go, the coronavirus page will be what you see when you first go to our website. And then there's a series of buttons, and one of them is, how many states are providing for cyber in-person appearances? How many are providing for online oral arguments? And all those, you can see just the map, but then you can go to state-by-state profiles. Because as we all know, all state courts are not created equal. And in some states like Colorado, California, Florida to some extent, have a lot of what we call uniformity, where the Chief Justice may have broad authorities to make decisions about moving judges, about waiving statute of limitations. But in some states that Chief Justice Heck likes to call grassroots states, I call them decentralized states, like Texas, like Georgia, Washington State even. They're not state funded. Local trial courts still have a high level of authority to establish their own rules, and the courthouses are not under the direct authority or the presiding judges at the trial court level of the Chief Justice. So, but even in California, we found that the Chief Justice there had to get numerous executive orders from the governor to be able to make decisions about the best way to approach courts. Janet DeFiore in New York, working with Governor Cuomo there, had to negotiate with the New York governor over what she needed to have in order to operate the courts. So one of the things we've tried to do, and we have a rapid response team, and we have a series of advisory committees on post-pandemic planning to resume business that's looking at a variety of things, including what types of authorities going forward do chief justices need to have when there's a national emergency. And that could be whether it's a national disaster or a pandemic. I'll give you an example. Georgia is one. Chief Justice Milton in Georgia, when he was an associate justice, had chaired their state committee on developing a continuity of operation plan. We refer to those as COOP plans. And this was several years ago, around the time that Ebola had reared its head. And because that's a decentralized state, he does not have the authority to move judges, to move people, to determine what types of cases might need to be given a higher priority with a reduced workforce. So they actually passed a statute in Georgia giving the Chief Justice some emergency powers if there's been a national emergency or a national pandemic plan. So one of the things that we're going to be looking at is moving forward, what type of emergency authorities do we need? I'll give you another example of that. When Katrina hit Louisiana, there was some question about whether the governor had the authority without the legislature being in session, and not only being in session, the governor couldn't find the legislators. Everybody was evacuating. And so the Chief Justice at that time, based on that constitutional theory that if there's a gap between the statutes and the courts can fill those, and just made a decision. Nobody really contested it because something had to be done. I mean, people were dying. We had people in prison that had to be removed. And so the acting Chief Justice at that time just made a ruling, and then we knew that there would probably be lawsuits down the road to figure out could have, should have, would have. So what we want to do is take advantage of the lessons that we've learned during this pandemic to also look at what additional authorities, what would we think would have made the court stronger, more responsive to the public if the Chief Justices had had some clear statutory authority laid out and what kinds of decisions they could make.
So in other words, could the courts have been more agile in responding to this new landscape if they had a different set of rights and prerogatives to make those moves?
And we're not, we don't in any way, we want to be seen as a partner in this, the three-legged stool called the three branches. Sometimes I think it's sharing of authority, not really separation of authority, because certainly the governor, you want the governor to establish what those guidelines are, like social distancing and encouraging people to telework. So it's not that we want to usurp or change that, but if we had some authority to make decisions about moratorium on fines and fees, moratoriums on evictions, more, you see what I mean? I mean, rather than that have to go through an executive or a legislative process.
Right. Just we need to move fast in an environment like this.
Right.
Can you talk a little bit, Mary, about the trends we're seeing at a macro level in terms of, especially the technology that we're seeing courts adopt? You made a comment in a previous conversation we had about the fact we're seeing years of change compressed into, several months here. Can you talk a little bit about that perspective and what that translates into in terms of actual change on the ground?
People that know me laugh because I'm kind of a student of the Federalist Papers. I knew
Right.
Hamilton before he became, a star.
A celebrity.
but I would say that, I would like to say that from time to time, I would say if Madison or Adams came back, they could still practice in our courts.
Right. They wouldn't miss a beat.
The rules of evidence, some of the practices that we have date back to the colonial period, pre-revolutionary period.
Right.
And so what I've seen as a silver lining, if I could use that term, to us having to be agile, and that's not an adjective that you usually apply to either lawyers or judges.
That's true.
Is that I've seen more acceptance just by virtue of necessity, in the last 3 months than I would say in the last 3 decades. And you're talking about judges who thought Zoom was an automobile commercial. And now we've got judges who are daily using Zoom for a variety of not just case-related, but administrative-related processes.
Right. And how are you seeing the mindset change maybe? Are you seeing what you view as a permanent change in how the courts are thinking about technology? Have you seen people's minds change about the impact technology could have, and maybe just in a foundational way, how we operate the courts?
And I think you could start with the Supreme Courts, the state Supreme Courts. We've got over 40 jurisdictions that their oral arguments are on a Zoom or a WebEx or a virtual platform. And they, and I think that is going to, I think part of that is going to become one of the lessons that we retain. And as far as I know, no one's flushed the toilet during those. That was some of the concerns,
right?
With if you just have audio. But we've also seen, but most of the state, if not all of the state courts and territories, live stream their oral arguments previously. So, the camera in the courtroom issue was not necessarily one of the challenges. One of the challenges you may recall early on when there started to be an increase in the commercial use of, let's say, the Zoom platform, because that's become kind of the platform of preference by courts, was a privacy issue. I think some of you may remember reading all articles of paper. I have to give them a lot of credit that within 48, 72 hours of that, they had solved that problem. And so once the chief justices and their associate justices became comfortable, they started trying it. And what's interesting to me is
these were the privacy issues, the Zoom bombing issue that we saw crop up.
Yeah, right. Could somebody pop in and there's a word for that. What
Zoom bombing? That's right. Yeah. And we in fact just interviewed a couple of experts on that topic last week, and again, you can solve that with
exactly. And so
permissions
right
and
away,
passwords.
We started hosting webinars, sharing what we learned. So if you're going to go online for your oral argument, here's a checklist of the 10 things you need to ask yourself, regardless of what platform. And just for all of you, orientation for lawyers was one of the biggest, the biggest criteria. And I won't name the state, but when they would, just like you did, Jack, say, okay, if you need to test this out, go to this link and test it out. I think going forward in the future, that's going to be mandatory, because we would have lawyers, law firms to say, oh, we're cool. And then we would we would start the oral argument. They couldn't, like me today, they couldn't get on as quickly as they should, or they, their broadband wasn't where it should be to have a
Right.
clear picture, those kind of things. So I think what happened across the country is that as some of the jurisdictions were having positive experiences, including the lawyers that appeared before them, that was shared. And one of the reasons, as I said earlier, for the creation of the National Center for State Courts was to be able to share that information across the country. And so I think it started, I mean, the technological application started with the Supreme Court. And so as the Supreme Courts became comfortable, then you had trial court judges that either they were concerned about their own health, they were concerned about the attorney's health that was appearing before them, they were concerned about the health of the litigants. So it's kind of like, let's try a approach to what types of personal appearances can happen. And these were just standalone, motions, not and anybody at that point was thinking about a trial. But then we have, some of the younger judges and court executives saying, well, why can't we do a virtual trial? And so on May 18th, Texas performed the first, as far as we know, virtual trial. And what was interesting about it, and I think that where I think one thing that we can all embrace was the jury selection process. So think about resuming court, and most states have either had a moratorium or delayed civil trials. So we're worried about this tsunami of trials that's going to hit everybody, right?
Yeah,
and,
enormous backlog.
Exactly.
Forming.
And if they're jury trials, think about the voir dire process.
Yeah, what does jury selection look like?
200 people coming into a courtroom in a jury assembly room, right? I mean, how is this going to work and us be able to socially distance?
Taking
right?
tiny elevators in old buildings up to these
that are
one
12
at a time.
stories high.
Right.
And you can only put 2 people on the elevator. Do the math, right?
Yeah,
so,
it's just impractical.
Right. So we decided, well, let's see how this works. And so some of the lessons we learned. So think about, all of us have been in Zoom meetings. So you have the panel, right, of all the little pictures of everybody.
Well, the gallery view of everyone in the Zoom.
And you can only get maybe 24 or so. I don't know what the maximum number is, but let's say 18 to 24. So they decided to do the voir dire in 2 panels. And so you got a summons, and it would say, would you appear? And you could check it off. What was interesting about this is there was a presiding judge over the jury selection process. And then there was a technology judge who handled all the requests that people had to make sure they were on the Zoom call and that kind of thing. His name's Judge Miskell in Texas. Really, really innovative judge. And she laughed because her 800 number was, if you have questions, call. Well, she would have these potential jurors call because they thought it was a scam. Really? We're going to do jury selection online. And so it was kind of like, Christmas morning for all of us who were awaiting, May 18th in Texas. And so it comes up, it looks like the Brady Bunch, right? You've got everybody up here. You've got the 2 attorneys, you've got the presiding judge, and you've got the technology judge, as I'll call her. And it began just like any other jury selection process that all of us have witnessed before. The judge gave kind of the orientation to the jurors about, if you because you didn't want people, because they were in their pajamas like you, Jack, leaving
Right.
the panel, you know.
Right.
And so they started with the questions, and it was the questions that you would. This was the case was between an insurance company and a claimant, the plaintiff, and so the plaintiff's attorney would ask, you know, how many of you have insurance policies on your house or your car, whatever you. So they all raise their hands. But what was it? And then they would ask other questions. Have you ever filed a claim? You know, the ones that we always think about. What was interesting to me, though, was that the introductory questions that you usually have from the judge, is there anyone who cannot serve on this jury? Not one person raised their hand. And those of us that were watching thought, my gosh, this has never happened before. The other thing
and you would
was,
benchmark this against what would a normal rate look like? This is 0 compared to typically 20%, or what would you?
Exactly. And I think what was kind of interesting was if you just looked at the panel, it looked very inclusive by age, by race, by gender. And after we went through the voir dire process, and if you have any questions procedurally how that went, I can answer. But to get to the assessment at the end, where we asked them questions about the experience, all of them said they would do it again. And maybe a third of the panel had served as jurors before, and their observation was that they could see the evidence better. Just think if you have documents, you know, they could see those much better. That they could see each other because they did go to deliberation. They said they were also asked, well, how many of you would have requested an excusal if we hadn't done this online? And you know, there were about half of them that said that they would not have come to the courthouse because of being concerned about safety. And I'm talking about, you know, social distancing, having to wear a mask and all of that.
But I'm sure there's a decent number of those that wouldn't have come even post-pandemic because of the inconvenience of attending the physical trial.
Right. And some of those said that they would do it now because coming to the courthouse was inconvenient. When we talked earlier about what keeps me up at night, and we mentioned social justice, I don't know that we think of jury services being economically disenfranchises groups. And what I mean by that is because unlike National Guard duty, there is not a requirement for employers to provide people with jury leave. Right. So if you happen to work for an employer who does not provide for jury leave, it is economically preventative from you saying, I can afford to take 1 or 2 or 3 days off from work, drive down to the courthouse, park, and participate on a jury. And so we actually believe that by looking at least the jury selection process being cyber, I mean, it's something that perhaps all of us could agree on under certain conditions, that it will expand the inclusiveness of the jury pool. So one of the things we're working on right now is with 5 states, we have a pilot, is trying to bridge the digital divide like education is. You know, you hear all the time about, well, schools are going to provide this education online, but you have this group of students who either don't have a device or they don't have broadband connectivity at home, right? Same thing you could say applies to people serving on juries. So we're working with some of our national corporate partners that if you don't have a device or you don't have broadband coverage, we'll provide that for you. And with the devices, it could be rather than having to come down to the courthouse, you'd go to a local library or community college or, you know, a meeting room at, you know, Target or Walmart. I'm just trying to, you know, and that then we would have laptops or tablets there that you would be asked to arrive at a certain time to participate in a voir dire panel. So we believe that that looking at least the jury selection process cyberly, and because we want some metrics, we want to be able to say, how do lawyers feel about it? How did the jurors feel about it? Just the jury selection process. That we're going to try to move forward with that, and then hopefully there are, and the 5 states that are participating in that are Texas, Georgia, Florida, Arizona, New Jersey, and Michigan. New Jersey, for instance, still has grand juries, so they're going to look at it for the grand jury selection process. One of the interesting things I would say about deliberation, most of us, have 2 monitors, because especially if you're on a Zoom meeting and there are a lot of documents, you got a Dropbox, and so you don't want to leave the Zoom meeting, but you want to be able to look at the documents. We hadn't anticipated that for the jury deliberation, and so some of the jurors wanted to be able to look at a document that the judge had said you could look at, but when they tried to access it through the Dropbox, because they only had 1 monitor, it dropped them off the Zoom call.
Right.
But
right.
I mean,
So you need to find a way of replacing.
Yeah. And so we also think, and in some states, you have a bailiff or someone who is kind of assigned to the jury during deliberation. So if they want things, we think that you're going to have, whether it's a court employee, that somebody needs to be there to help them if there are any technological issues that arrive during deliberation. But on the whole, the lawyers that participated as well as the jurors thought it was great.
So, Mary, so interesting. We had Richard Susskind on the show a couple of weeks ago, and as you know, he talks about this concept of the courts being a service, not a place.
Right.
And it sounds like in at least some jurisdictions, this future that we thought was maybe decades away, if it would ever be realized, of courts being completely virtual and happening over a virtual conference call, over a video call, that's here today. And it sounds like the reception from judges and jurors and the lawyers representing their clients is actually very positive overall. Are you hearing anything on the negative side, or any feedback that you think we need to incorporate into what the next iterations of this look like?
No, I think as lawyers, we need to say, okay, we're really good at identifying the differences in cases and evidence, and I think we're good at looking at constitutional rights that need to be protected. And what we have to think of, is there another way to do that than we've done before? I'll give you an example. The issue that always comes up when we talk about criminal trials cyberly is the confrontation clause, right? Well, what was the definition of confrontation in 1776 versus today? What was behind the confrontation clause? What was our reason for thinking that was so important? And how could we provide for those same kinds of constitutional protections in cyber space, for instance? And there have been a lot of discussions about what that might look like, right? And so I think, but for instance, in child abuse and neglect cases where you have a young victim who's been abused by the defendant, allegedly abused by the defendant, there have been practices where the young victim is actually questioned in the judge's chamber without the defendant being physically in the room. That has withstood the test of the confrontation clause challenge. Okay. So I think we just have to think about that, and maybe we can find attorneys that are willing to work with their clients to see how that might work. I think the other thing is the humanity or the the human aspect of questioning jurors, right?
Right.
And I have to tell you, it was really interesting to see these two attorneys question the panel. There was some age difference. There was gender and racial difference between the two attorneys. And one attorney, it was very traditional, very friendly, follow-up questions. The other attorney, the first thing she said to everybody is said, well, now just sit back, take a deep breath, and pretend this is Jury Survivor Island. Well, you could see everybody immediately, I don't want to get voted off the island, right?
They get it. They understand exactly what that means.
Absolutely. But I'm just saying, I think as we move forward, we'll learn things. So for instance, after they had the questions, it was okay. So let's say if you want to approach the bench for a bench conference, how do you do that in a Zoom environment? And we hadn't really thought that through. So it took a couple of minutes for Judge Miskell, the technology judge, said, well, I'll just create a Zoom workroom and send the two attorneys and the judge to the Zoom workroom. Right? And everybody else just stayed in the Zoom call.
And Mary, you shared with me a link, and we can maybe put this in the show notes, but there's actually a YouTube link that you shared of this virtual jury selection.
Jury selection. Yeah. And so I'm glad you raised the YouTube issue. So you were saying what some of the pushback we get. Another pushback we've gotten from different advocacy groups is, most state constitutions provide for open courts.
Right.
Okay. How are you going to do that in a virtual environment? Well, Texas decided to do that by using YouTube. And so anybody that wanted to could see YouTube. Well, people that, represent allegedly undocumented workers or victims of domestic violence said that, having everybody be able to see their clients on YouTube created a security concern. Because it's different from somebody having to get in their car and come down to the courthouse, right? Versus just being able to get on YouTube and seeing what's going on.
Yeah, open courts meaning
exactly
anyone in the immediate vicinity can attend versus the billions of people on the internet can see this on YouTube.
And they shut down that YouTube link. We agreed because this was kind of a test case to be able to share it. But the question is that once you had, let's say, a cyber jury trial or a jury selection, would you not make it available?
Right. I would encourage everyone listening to check out this YouTube link we'll make available in the show notes, because it does show that the technical judge you're referencing walking through this very precise process of setting everyone up in the same way, making sure everyone's phone is in landscape versus portrait mode and helping everyone out. And it's a good, half hour of almost technical calibration before proceedings really get underway. So Mary, I'd like to conclude our conversation. This has been so informative and so useful, but in a previous interview, I heard you mention the fact that you are guided by Alexander Hamilton's remark, and you talked about being a fan of the founders earlier, that nothing contributes more to the public's respect and esteem for government than the effective administration of justice. And we're obviously over the last week seeing that some of the structural inequalities that exist in our society are causing an uprising where maybe that respect and esteem for the government is not there in the way that we would hope to see. You've talked over the course of our conversation about how maybe this technological transformation that's happening in the courts actually improves access and improves the diversity of jury pools and helps level the playing field across different racial and economic groups to be able to access all aspects of the court system. Can you talk just for a moment about what you believe the opportunity is in all of this and what you might hope to see the enduring impact of as you described, the silver lining of this coronavirus pandemic on what the continuing administration of justice might look like?
I think, I've talked generally about the inclusiveness, increasing the access opportunity. But I also think that especially given some of the frustration that we've seen played out in the streets across the country in the last week, it's listening to people. I think sometimes we call it procedural due process. That even though, let's say, in a marriage dissolution case, and you're a no-fault jurisdiction, and there's really just give me your names and let me sign the paper on the judge's side. Sometimes people need to process. They need to tell their story. And I think that if we're going to retain the public's trust and confidence in the court systems and in justice, they have to be heard. We can't just have kind of this grocery store revolving door of these high volume dockets. And so I think by people not having to drive to the court, by us being able to make the appearance in front of a judge less of a challenge, we'll have more time on the judicial side to listen, and we'll give citizens on the other side the opportunity to actually be in front of a judge. Most of you probably are familiar with drug courts as a concept. Well, drug courts, one of the key criteria of drugs court is that weekly appearance before a judge. We think everybody says that's one of the key metrics to the success. Well, how are you going to do that during a pandemic? Phone, FaceTime.
Right.
How can you do that? And so we have experience with that. I think also, when we've heard some of the vocal frustrations in the last week, it's been starting with law enforcement and the standards for use of force. Then it was the prosecutorial charging standards. So what's next? The jury.
Yeah. We
have to ensure that everybody can serve on a jury, that there should be no economic barriers to serving on a jury. And that digital divide, whether it's the fact that in some parts of Montana or West Virginia or Kentucky, you can't get broadband, we've got to make sure that we can expand the representatives of the jury service. Yeah. Because you want people that serve on juries to say, it was fair because I was there. And so I think that when I quote Hamilton, I think that the entire criminal justice process may be able to resurrect the public's trust in it if we can ensure that the court piece is where they have hope, that they can say it was fair because I was there.
That's a great note to end on, Mary. There's so much more we could talk about, and I do believe we'll need to have a follow-up conversation, but I really thank you for sharing your perspective today. It was so useful, and look forward to chatting with you again.
Absolutely. Keep safe.
You too.
Thanks for joining us on Daily Matters today, a podcast from Clio. Rate and review wherever you get your podcasts, and subscribe so that you never miss an episode. Daily Matters is produced by Andrew Booth, Sam Rosenthal, and Derek Bolin, and hosted by yours truly, Jack Newton. Thanks also to Clio, the world's leading cloud-based legal technology provider, for supporting this podcast. If you'd like to learn more about Clio, please visit clio.com.